So in particular, I'll be talking about data protection issues that might crop up in the context of the test and trace obligations that many licensed premises have. Matt is going to talk to you about publicising licensing decisions and the issues in respect of that. And Ruchi finally is going to talk to you about COVID passports and how they may work in the future. So starting with test and trace, and as Sue says, if there's any questions as we go through, please pop them in the Q&A. There will also be an opportunity for Q&A at the end of all three sessions. So it's undoubtedly been the most difficult year the licensed trade has experienced in living memory. And so it's perhaps unsurprising that data protection may not fall particularly high on the list of priorities. But of course, it's so important that licensed premises are very, very careful about data protection, because more and more citizens are taking an active role in seeking to enforce their data protection rights. And in light of the financial difficulties faced by licensed premises, really they can't afford to face claims for compensation or investigations by the Information Commissioner and fines for any mishandling of personal data. So it really is quite important. Now, of course, we know yesterday, Prime Minister Johnson brought the welcome news for the licensed trade that he expects from the 19th of July, all nightclubs will be reopened, venues will be able to return to full capacity, including theatres and cinemas, and that the law on mask wearing will be dropped, although of course many premises may decide to still have guidance about wearing masks inside of them. Now, the issue of test and trace doesn't appear to have come up in the Prime Minister's statement yesterday, and given we are still in the midst of a pandemic and probably entering a fourth wave now because of the Delta variant, it would be surprising if the test and trace requirements that are currently imposed on licensed premises should be lifted. And so what that really means is that it's likely that licensed premises are going to have to continue to collect personal data for test and trace purposes, and as a result to continue to comply with all of the data protection requirements necessitated by data processing. So if we just go to the next slide, Matt. So just by way of background, what sort of legal position are we in? And this will be familiar territory to many of you. So we know that venues in hospitality, the tourism and leisure industry, close contact services, community centres, village halls, they all have a requirement to ask every customer or visitor over the age of 16 to provide their name and contact details. They have to keep a record of all staff working on the premises and shift times on a given day and their contact details. And they have to keep records of customers, visitors and staff for 21 days and provide test information or provide that data to NHS Test and Trace when it's requested. And of course, they have to display the QR codes so that customers and visitors can check in using the NHS COVID-19 app as an alternative to providing their details. And of course, they have to comply generally with the General Data Protection Regulation. Now, hospitality venues, of course, have the additional requirement and must take reasonable steps to refuse entry to anyone who refuses to participate in the collection of contact details. And venues have the obligation under the regulations, the health protection regulations cited there, to refuse entry to anyone who refuses to participate. And venues have to satisfy themselves that all has been done that could reasonably be expected to refuse entry. And of course, the penalties if you're not complying with these types of collection of contact details are quite severe. You can be fined up to a maximum of £10,000 from a fixed penalty notice. The first penalty notice will be £1,000, but it goes all the way up to £10,000. And of course, all those requirements apply to on-site hospitality and to any events that take place on a premises. Those of you working in the licensed trade will be very familiar by now that, of course, if the food or beverages are being taken off-site immediately, just if it's a bar or restaurant only providing takeaways, then there's no obligation to be collecting the customer details in question. So what about personal data? Matt, if we go to the next slide. So when we're thinking about the collection of contact details, we are in the realm of personal data, but there's one thing I just want to be clear about before we delve into this, which is that when someone checks in using the QR code, so when they just scan on the QR code, your premises or the licensed premises is not actually collecting any data from them. So there's no obligations to worry about data protection law or data protection rules to any extent if someone is just scanning in using the QR code. So you don't need to worry about it in that context. But if someone hasn't checked in using the app, venues, of course, have to ask every customer and visitor for the following details. So when we think about personal data, we're thinking about the following things. A name is someone's personal data, so you're getting the name of the customer or visitor. Then you're also thinking about the contact details. So you're always going to get a contact phone number for each customer or visitor. But if a phone number is not available, you should be asking for their email address instead, or even for their postal details if there's no email address. All of those are personal data. Then the date, I should say date rather than data, of visit and the arrival time are also to be recorded, and they'll also be personal data of the individuals because they are linked back to the individuals, the particular time they arrived and the date that they visited. Where possible, you should also be collecting the departure time. And I should say that on that issue, the departure time is included in guidance, government guidance, but it's not actually a legal obligation to collect departure time. So all of the first three, the name, the contact details, date of visit and arrival time, you have a legal obligation to collect all of those. The departure time is suggested in government guidance, but it's not mandatory by law. And then finally, you should also make sure you've recorded the name of the assigned staff member to a person. So that will be in the context of particular venues that have staff assigned to different people. In the government guidance, they give the example of hairdressers, so it's unlikely that that type of thing will apply to those of you working in the licensed trade in the context of bars and restaurants. So there's no additional personal data that should be collected at all. That's all of the personal data that should be being collected. And you also have the obligation to make sure that there's a method of checking in that doesn't rely on the customer using a smartphone or other technology in order not to digitally exclude people who don't have access to those technologies. So I, for example, haven't downloaded the check-in app for my own data protection concerns about that app. But most of the venues that I have been visiting over the past few months have given me the option of manually writing my name or giving my own information in some other way when I book a reservation or something like that. So you should be doing that. Once all that data is collected, the question then for a licensed premises is, well, what obligations are associated with having this data under the data protection rules? And as I turn to these, what I want to emphasize first is that data protection is really nothing to be scared about. The underlying principles with data protection are all really about common sense, and they're just common sense statements about respecting other people's privacy. And so for contact tracing, they can be really boiled down to the following very basic rules. The first is this idea of data minimization. And as I've just indicated, the necessary information that you're required for test and trace purposes to collect are just the person's full name, contact details, and dates and times of their visit. And so if you're collecting anything more than that, you are at risk of breaching that data minimization principle. And because what data minimization means as a principle in the data protection law is that you should only be collecting as much personal data as is necessary for you to fulfill the purpose for which you're collecting personal data. So all you need in law is the full name, contact details, and date and time of visit. The guidance suggests also the departure time, so you can collect that. but anything going beyond that is likely to be a breach of the data minimization principle and cause you some difficulty. And in particular, what I'd emphasize is there's no requirement to collect information about a person's health condition. And you should really avoid doing that type of thing, because you might fall into difficulties, because when you collect health information, that's actually what we call special category personal data. And there's a whole different set of rules that you have to comply with when you're processing special category personal data. So only collect exactly what the government guidance and the legal framework requires you to collect, data minimization. If we go then to the next principle, this is called the integrity and confidentiality principle. And what this really is getting at, it's the idea that you should be keeping all of the personal data secure. Okay, so for example, if you're keeping a paper record of all of these things, it should be out of public sight and kept in a place where it cannot be accessed by anyone other than the relevant staff members. So what the Information Commissioner suggests is that rather than having, which I see a lot actually in bars and restaurants around Kennington and Vauxhall where I live, rather than having a list where you just have people signing their names and contact details that everyone can then look at the list and see the people who've gone in before them, what the Information Commissioner suggests is that you just have blank forms that people fill in and put in like a ballot box, a kind of election box, so that they're all go in there, but nobody else can see what anyone else's form says. And obviously the ideal would be if everyone was doing it electronically, and with electronic records you need to be making sure that as a minimum the information is kept on a password protected device, and really ideally an encrypted device. And in that regard, it's really important that your staff are aware of what they should and shouldn't be doing with customer information. And so making sure that staff understand the importance of data protection issues also falls within that principle of integrity and confidentiality. If we go to the next issue then that is likely to crop up, it's data retention and deletion, because there's a general requirement in data protection law that you not keep data longer than is necessary to keep it, and that you delete any data you do collect in a secure manner. So we know from the regulations that to support NHS test and trace, the requirement by law is that you hold the records for 21 days, because of course that reflects the incubation period for COVID-19, which can be up to 14 days, and an additional 7 days to allow time for testing and tracing. So the law very specifically says you should only be retaining the information for 21 days, and then afterwards disposing of it securely and carefully. And you know, to be honest, the 21-day requirement is actually quite useful from a licensed premises perspective, because it means that they're not burdened with processing more personal data than they need to be, and they don't face the risks that are attendant on having lots and lots of personal data which might be lost or leaked or whatever. If you only are retaining the personal data for 21 days, there's less of a chance of things going wrong. And of course, in terms of when we talk about deleting securely, what we're really talking about is if it's paper records, you make sure you're shredding the documents, you're not just throwing them all in a green bin, unshredded. And if it's electronic files, that you're making sure the electronic files are actually permanently deleted rather than retained on some backup disks or servers. There's no need to do that at all. You should not be keeping things as a just in case principle. You should be deleting everything after 21 days. Turning then to the next principle you need to be thinking about, this is the idea of acting lawfully, fairly, and transparently. And what this effectively means is that you have to be clear and honest and open with people when you're collecting their personal data. And in that regard, what you need to be doing is explaining to people what it is you are collecting, who it is you're sharing the personal data with, why you're collecting the personal data, and how long it will be retained for. And that doesn't mean you have to inform every single visitor or customer individually when they attend the licensed premises. Really, the best way to provide information is by way of what's called a privacy notice. And I'm sure most of you will have come across these privacy notices. They're often just short pieces. Either you can display them on your window or on your website. And it just sets out what the data will be used for and the circumstances in which it might be accessed by NHS Test and Trace. There's an example of a privacy notice if you are in any doubt about what you should be putting into it. In the government guidance on test and trace at Annex C of the government guidance. So I'd encourage anyone who doesn't have a privacy notice, as I say, on a website or displayed in a window, to check that guidance and adapt rather the wording in that guidance for their own uses. It should probably say something like the information is being collected to assist NHS Test and Trace for tracing. It'll be given to NHS Test and Trace on request in the event that it's required for contact tracing. We won't use it for any other purpose. We'll delete it within after 21 days. It'll be kept here at, and then put in the name of the premises, and reminding people of their rights to access their personal data. And then just something like a line saying, if you have any questions about this notice, please contact, and then whatever the details of the relevant person in your organization are who might be contacted. You should also remember you might need to offer additional support to people who are visually impaired or who don't have English as a first language in assisting them to understand the information if anyone brings that to your attention. So do bear that in mind. And when I think about just the first of those three words, lawful, you always have to have a lawful basis for processing personal data. And in this context, for most of you as licensed premises, your lawful basis is the fact that you have a legal obligation under the regulations to process all of this personal data. So you don't really need to actively worry about what's your lawful basis. There's a legal obligation under the regulations. Finally, then on this slide, the purpose limitation principle is also important. And this is the idea that you can't use personal data for a purpose that is incompatible with the purpose you collected it for. So you're collecting personal data as a licensed premises for NHS test and trace purposes. And so you wouldn't collect that usually in the course of your business. And so it must only be used, therefore, to share information with NHS Test and Trace. What it should not be used for is other purposes like marketing, I know, tempting as it is, profiling, analysis, or any sort of other purposes that are not related to the contact tracing goal. Otherwise, you are likely to be in breach of GDPR. So I know, given in the last 12 months, lots of organizations' customer lists have been reduced dramatically because, of course, they haven't been dealing with customers regularly. So there is a temptation to mine the sort of treasure trove of information that is given to you under the collection of contact details for NHS Test and Trace. There is that temptation, but doing so would, I think, be a breach of the purpose limitation principle. Now, some places are sort of having an opt-in tick box for customers where they say, you know, you're giving us this information for NHS contact test and trace purposes. However, would you also like to opt in to marketing emails while you're giving us this information? There's a bit of lack of clarity on whether that would comply with data protection law. I have concerns that it wouldn't be a lawful approach because the requirements for a valid consent under GDPR are quite strict. And it's not, the law is not very keen on this idea of bundling in consents, which are sort of tacked onto other things, because consent should always be very specific and freely given. So I suggest if you are thinking about some sort of opt-in where you sort of get people to also opt into marketing when you're collecting their details, that you do try and get specific legal advice before on exactly how it's going to be worded before you go down that route. In terms of the next slide, Matt, thanks. There's a few other principles you need to be thinking about. The first of those is the accuracy principle. So this is the idea that any personal data you hold, you should be taking steps to ensure that it is accurate. So what does that require in this context? Well, in the context of maintaining records of staff, customers, and visitors, all you need to do is record the information the customer or visitor provides to you in an accurate way. So there will be isolated instances, I'm sure many working in the licensed trade have seen these, where you will reasonably believe that the information that you're being given is wrong or out of date because someone doesn't necessarily want to be tested and traced. And so you can ask, of course, the customer for clarification, but the reality is that lots of people are going to provide false information. You know, they might change a digit on their phone number or something like that. And it will be impossible for you to be double checking all of that information. So as long as you're accurately recording the information that they're providing to you, you're likely to meet your the requirements of that data protection principle, the accuracy principle. Then if we go on to the next bubble, we've got sharing personal data. So when you're keeping all of the records of staff, customers, and visitors for contact tracing purposes, you should only share the information when it's requested by a legitimate public health authority. So it's only if you're contacted by a contact tracing scheme and you are asked to provide details of individuals who have visited your premises that you should be sharing. And it's quite important that you be checking to ensure that the callers are genuine. And there's guidance again on the government website about what the test and trace people will say and won't say to you, or what they will ask you to do and won't ask you to do, because you do need to be cautious about fraudsters and scammers just trying to get lots of information to target certain people. There'll be a narrow range of circumstances where you might have to share the information with other people. For example, say there was a fight in the pub one night and the police came looking for information. They would have to convince you that they have an exemption under the Data Protection Act before you give them the information. But it might certainly be lawful to share the information with the police in those types of circumstances. Then we just have to finally think about the data protection rights of individuals, because when you're collecting all of this information from individuals, they do also have certain rights in respect of that information. And for contact tracing, those rights include, first of all, the right of access to the personal data you hold on them. So they have a right to know what personal information you're holding on them. They also have a right to what's called rectification. So this is the right to ask for any factually incorrect or inaccurate data to be corrected. And there's various other rights too, including the right to erasure. And those rights can be exercised verbally or in writing. So it's really important that your staff understand when they're being asked for data protection issues, so that your staff are trained effectively to recognize any requests about access or rectification, for example. If we go on to the next slide, Matt. So just to summarize the position, and the Information Commissioner has really helpfully put out a guidance document where she looks at all of the things that you should be doing with customer and visitor details in the context of testing and tracing. And she summarized it with the letters A to E. Okay, so A is for ask only for what's needed. So just as a reminder, you should only ask people for the specific information that has been set out in government guidance. And you should not ask people to prove their details with identity verification type documents, unless there's a standard practice in your business, you know, like age verification in pubs or something like that. B stands for be transparent with customers. So again, as I said already, you have to be clear, be honest, be open about what you're doing with the personal data when you collect it, telling them why you need it, what you'll do with it. And that's all done through a privacy notice on your website, on your window, and just telling people as they're signing up. If you already collect customer data for bookings, you should make it clear that the personal data will also be used for test and trace purposes. C stands for carefully store the data. So again, as I've said, look after the personal data you collect. It is important information. It is valuable information if it gets into the wrong hands. And that means keeping it secure on a device if you're collecting records digitally, or in the context of paper records, making sure they're always out of public sight. D then stands for don't use it for other purposes. So don't be using the personal information that you collect for contact tracing or other purposes, such as direct marketing, profiling. And then E stands for erase after 21 days. So erase it in line with government guidance. So don't keep the personal data for longer than the government guidelines specify. And it's important that you dispose of the data securely to reduce the risk of someone else accessing the personal data. And again, as I said already, if it's paper, you're going to be shredding it. And if it is electronic, making sure that it is permanently deleted. So I've covered a lot of information there, but hopefully that is a helpful overview of the data protection requirements that licensed premises face as a result of the test and trace scheme. I'm now going to hand over to Matt, who's going to talk to you about the rather exciting sidebars of Shane.
Thank you very much, John, and helpful reminder of some of the basic data protection principles, which will hopefully be useful, because this is a slightly more in-depth dive into one aspect of data protection that I was interested in. I thought you might be interested in too. So this is part of a series of webinars put on by the IOL on the theme of reopening and recovery. Now, strictly speaking, because my presentation is on the subject of licensing outcomes, that's not a COVID specific topic, but it occurred to me that this might be an interesting topic because, as with many aspects of our lives, we're thinking, or we've taken the last 18 months to think about how we can do things differently, maybe even how we can do things better. And I thought, you know, maybe this might be one of those topics. And then at Cornerstone, we've been very busy doing exactly that, reflecting on how we can improve our website. It's been extensively focus grouped. We've shelled out thousands for consultants, and I'm really pleased to give you a sneak preview of the beta site, which we're currently testing. We welcome your feedback. We've got this glamorous new feature on the website. I don't know what you think. If you've got any comments, feedback, we'd obviously really appreciate it. Okay. So I wonder how many of the licensing authorities, and this question is primarily directed at licensing authorities for reasons that will be obvious as we go through, how many of the licensing authorities here represented here today routinely publish their licensing outcomes or publicize their licensing outcomes? By licensing outcomes, I'm talking about really any decision that's taken in relation to an individual license. So that might be a refusal of an application for a new license. It might be suspending or revoking or doing something else to an existing license. It might simply be a warning against a license holder. So no formal action as such, but maybe a written or an oral warning, or at the more formal end of the scale, prosecuting someone for breaching licensing laws and securing their conviction. And by publicize, I'm talking about press releases, news items on the council's website, giving statements to the media, things like that. Now, I've worked for lots of different licensing authorities across the country, and the attitude towards publication and publicising licensing outcomes differs quite wildly, I found, and some authorities are quite happy to publicise and promote their work, and others are a little bit more cautious and worried about maybe some of the legal difficulties or legal concerns that putting people's name out into the public domain might represent. So I'll acknowledge from the very outset that there are good reasons for doing it and bad reasons for being cautious about it. But I'll give you this example. This is the kind of example I'm thinking about here. So this is an article from the Manchester Evening News published in February. And as you can see on the screen, it's a story about a Bolton Council licensed private hire driver who, as we can see from the article, his license was revoked, a pretty serious case of misconduct. But we can infer from the story that the driver is never named at any point in the article, that the decision was made in closed session with the public being excluded, and although a summary of the decision has evidently been made public as the law requires, no personal information that would be sufficient to identify the driver has been made. And my question for you is whether we should, or whether licensing authorities should be exposing drivers in this situation where they've gone through a formal procedure, the elected representatives or perhaps an officer under, a professional officer under delegated authority has found that there's something in serious allegations against them and they represent a risk to the public. And you can see that this was a particularly serious case here because the license was revoked with immediate effect. And we know that is reserved for only the most serious cases. So if we are confident enough that the driver is a risk to public safety, why do we not go a little bit further and identify them? Well, as I said, in some cases that might be appropriate, in other cases it might not. So why should we publicize licensing outcomes? I think there are good reasons and good reasons for doing so. Firstly, it can improve public understanding of the local licensing system. So there's, particularly in the current climate, there's so much misunderstanding about what local authorities do. And I think anything that licensing authorities can do to inform the public about what they do. A lot of licensing work takes place behind the scenes, particularly when we're dealing with exercise of delegated authority. I think it's really important to put as much information as possible out there. So not only, hopefully, if we can improve public understanding, we also improve public confidence in the licensing system. So if the public is properly informed about licensing outcomes, hopefully those two things follow. At least that's the ideal. Secondly, we're talking about scrutiny. Now, as public authorities, licensing authorities should be exposed to as much scrutiny as possible. But I also like to think of it in a different way. And if you've heard me talk about really anything to do with taxis, in particular, any of the IOL events, you might have picked up that one of my interests is holding license holders to account, that they hold positions of trust and responsibility and power in some cases, particularly with taxi drivers. And it's right that their conduct should be scrutinized as well. So scrutinizing both the licensing authority and people in a position of responsibility in our communities. And finally, deterrence. Now, sometimes there's a little bit of hesitation about the role that deterrence plays in the licensing system. In my opinion, it does. It's not by any means the primary objective, but it's part, I think it factors into most decisions. And as it were, naming and shaming can or could have a powerful deterrent effect, might discourage others from stepping out of line. If their name, address is being put out in the public domain, that could have a really powerful deterrent effect. So I think those are some of the reasons why we might want to publicize licensing outcomes, but on the flip side, there are good reasons in some cases for not doing so. So firstly, there are concerns about defamation and data protection rules, which could pose financial and reputational risks to the licensing authority. So that provides a pretty good reason for being cautious in this area. Secondly, some authorities and some people today might take the view it's not necessary. So to go back to that Manchester Evening News article, the details of this case have been reported. We know the reasons why the driver's license has been revoked. And at the end of the day, that driver's been taken off the road. So why do we need to go further and put the boot in or rub salt in the wound and put his details out there in the public domain? Particularly, as is often the case, we're dealing with non-conviction cases. That driver may never have been prosecuted, let alone convicted of anything formally in court. So again, there's reason for caution there. And well, I've kind of alluded to it already, consequences for the license holder. I recently had an inquiry from a local licensing authority that was worried about, well, if we put the they had a difference of opinion with their comms team about how much information gets put out when the council prosecutes someone successfully. And she was worried that putting someone's name, age, and address might result in someone putting a brick through their window. Well, possibly, but I don't think in law, at least, the council would be held liable for, a clearly unlawful act by a third party. But nonetheless, it's part of the consideration. So there's understandably some concern about the consequences for the individual if their details are made public. Now, in my experience, and in preparing for this presentation, it seems that licensing authorities are generally more comfortable with naming and shaming specific licensed premises. So when there's not an obvious name attached to the building, although obviously there are particular names, license holder, DPS, employees, that kind of thing. And also individuals who are convicted of criminal offences in open court. Authorities seem a little bit more squeamish when it comes to publicising the detail of individuals, particularly taxi drivers, who've had actions taken against their licence in committee under delegated authority, not in a courtroom setting. So in this presentation, I'll be looking at some of the data protection concerns that might arise when we're thinking about how much publicity to give a licensing outcome. I'm not going to focus very much at all on defamation. That's not really my specialist area. And generally, in my experience, your colleagues in the communications team will have attended media law training courses, and they'll know enough to, avoid the main defamation risks when issuing statements on behalf of the authority. But really, it's to provoke a discussion, maybe for you to go away and talk with your licensing teams, legal teams, communications teams, and think, well, is there more we can do to shed greater light on the work of the licensing team? So I think I already summarized the licensing outcomes I'm talking about, but this is how I'm going to break it down. So I think really there are three categories of licensing outcome in this context: conviction in open court, decisions made in open session, decisions made in closed sessions. And in each case, slightly different data protection considerations arise. So we'll start with the first scenario, which is conviction in open court. And I've taken that first because in some ways it's the easiest. Well, my bubbles are really malfunctioning here. I'm not sure what's going on. I'll work with what I've got. So the starting point here, and really it's relatively straightforward. Your starting point is that the defendant has been prosecuted for some kind of licensing offence, and they've been found guilty in open court. And if you spent any time in the magistrates' courts on prosecutions, appeals, I'm sure, will have picked up by a process of osmosis, if not been told explicitly, that there's this principle called the open justice principle. And the judges place tremendous value on this and actually quite fiercely defend it. And I'll give you a quote from a case in 2008. This is a quote from a Court of Appeal case, and it was a challenge by a newspaper who wanted to overturn some reporting restrictions. And the court said this: it's an important aspect of the public interest in the administration of justice that the identity of those convicted and sentenced for criminal offences should not be concealed. Uncomfortable though it frequently may be for the defendant, that is a normal consequence of his crime. So that's your starting point, that these matters have already been aired in open court and the defendant has put themselves there by their criminal conduct. Now, from a data protection perspective, we're dealing with criminal offence data because this refers to a criminal conviction, and John's already alluded to the slightly complex set of rules that apply when we're processing, in this case, making public somebody's criminal record. And what is required by the GDPR in that situation is an additional condition. So John has already talked about the legal, you need a lawful basis. That's your kind of starting point for processing data. But if you're processing criminal offence data or special category data, you need an additional condition to justify and to make lawful that processing. Now, there are a number of those additional conditions set out in the Data Protection Act 2018, but the one that I think would apply here is whether the data subject, that is the defendant, has manifestly made public their criminal behaviour. And the courts have considered this too. There was a challenge by an individual who had committed a crime, been convicted, and if you type their name into Google, hey presto, an old story appeared about their criminal conviction. And this was challenged on several grounds, including data protection. And the High Court in 2018, a case called NT1 versus Google, said that someone in that situation, by committing a criminal offence and being convicted of it in open court, has manifestly made public that behaviour. So that provides, or that in that case, that provided a justification for Google to continue publishing an article about that person's criminal history. And the same, I think, would apply in our context, whether when we're giving greater publicity to licensing outcomes. The inquiry I had from the local authority quite recently that I mentioned a moment ago was about how much information do we share? Isn't it enough just to give that person's name? Well, if that person has a totally unique name, maybe, but actually it's quite common to share a name, particularly in larger towns and cities. And the standard advice in media law training courses for journalists is you give name, age, and their street. And that avoids the risk of misidentification and inadvertently defaming the wrong person. So that would be my advice too. Name, age, and address. Thinking back to what John said about data minimization, think very carefully about what's necessary to identify that person and how much of the case you report in any publicity you give it. But in general, name, age, and address would probably be enough, and a basic explanation of what they've been convicted of. What about, I've got to sort those bubbles out for next time. What about non-conviction outcomes? So we've done conviction in open court. We move now into the realm of local authority decision making. So we've got, on the one hand, decisions made in open session, decisions made in closed session. And these can be, when I say open session, I'm talking about decisions made by committee in a public meeting, or decisions made under delegated authority where a record of the decision is made available for inspection for anyone who's interested to see it. For open decisions, for decisions made in open sessions, the analysis is relatively straightforward, I think. So the decision has been made in public. So a little bit like the discussion we had about decisions made in open court. I think publishing or publicising the decision can be seen as part of the exercise of licensing functions. Remember my 3 suggestions for why it's a good idea to give publicity to licensing outcomes: improving public awareness and understanding and confidence in the licensing system. I think that's part of the licensing authority statutory licensing functions. So I think there's in other words, a public task, legal basis for publicising the outcome. It gets a little bit more complex when we move in, it gets a bit more complex when we move into closed session, because the reason why we're in closed session is usually because we're dealing with something sensitive. So it might be criminal behaviour, it might be allegations of criminal behaviour, it might be allegations involving vulnerable witnesses, all sorts of things like that. But before I look at the data protection side of this, I just wanted to make a comment about the procedural decision to go into closed session, because a conscious decision and a resolution is required if we're in a meeting to go into closed session. And we do that under powers in the Local Government Act 1972. It's power to exclude the public or to withhold a record of a delegated decision from inspection. And we do that because if the matter was discussed and decision made public, we'd be at risk of disclosing exempt information. Now, the categories of exempt information are, for the lawyers in the room will know, Schedule 12A of the 1972 Act, and there's a list of about 8 or 12, I can't quite remember off the top of my head. Paragraphs 1 and 2 are the ones we're thinking about here. So information relating to an individual or information that might reveal the identity of an individual, those are usually, that's going to be the justification for going into closed session. Now, as I suggested, there are often good reasons for going into closed session, particularly in taxi cases, where potentially quite serious, damaging, sensitive allegations might be made against the license holder. And based on a sample of the cases I've recently been involved in, we're talking about involvement in child sexual exploitation, domestic abuse, all sorts of quite private, sensitive, and damaging matters. On the other hand, though, it shouldn't be the case that, at least as far as I'm concerned, it shouldn't be the case that all taxi cases are automatically dealt with in closed session. The power to go into closed session, the power to exclude the public is qualified, and it would only apply, so information is only exempt if the public interest in maintaining the exemption outweighs the public interest in disclosing the information. So a balancing exercise is required. It should never be an automatic response. And in some cases, I think there's a good reason for not going into closed session, even though you are dealing with an individual or an individual license holder. Now, here's a thought for anyone who advises committees on this. Often, especially when we're dealing with sensitive allegations, there's good reason for going into closed session, not only to protect the interests of the license holder, but also potentially to protect the interests of third parties like complainants, many of whom are vulnerable, quite young, and don't want their name made public for understandable reasons. So it might be the case that you hear the evidence in closed session, but what about this as a suggestion? I've not seen it done, and I'd be interested to know people's views on this. If the committee decides that this is a serious allegation and they're satisfied either that the allegation is true or that it's sufficiently plausible to justify taking a serious step like revoking a license, why not go back into open session to announce the decision? The public interest considerations at that stage, I think, are different, and potentially the public interest in disclosing more information about the decision than would be the case if the whole thing was dealt with in closed session, I think potentially outweighs the public interest in maintaining the exemption. As I said right at the beginning, although it's not a court of law, the licensing process is a formal one. Decisions are being made either by elected representatives or professional decision makers. And so it's not the case that this is a very casual thing. This is a formal finding that someone has behaved in a way that justifies taking their livelihood away. So why not be more transparent, give more detail to the public, and lift some of the restrictions that would otherwise be applicable on publicising and reporting details of the case. So that's a slightly side comment on the operation of the Local Government Act. As I said, I'd be really interested to know if anyone thinks I'm talking absolute rubbish on that, or whether anyone would be brave enough to try it out, and I'd come and defend you in a judicial review if necessary. But I wanted to talk about the data protection sides of things. So I think I've covered off my point about exempt information. Where we're dealing with criminal convictions, I think more or less the same approach would apply as I discussed in the first part of the talk. So the license holder has been convicted of some relevant offence in open court, so that's a matter of public record. That's out there, that's been made public by the data subject. So I don't think there's too much of a problem in publicising that, although well, I'll come back to a caveat in a moment. The more tricky area is non-conviction information. So those, as you can see in the final two bubbles on the screen, those potentially break down in two ways: allegations of criminal behaviour, but which have not been formally proven in a court. So it might be an arrest, it might be a charge, it might simply be a report to the police that's been passed on and unhelpfully not properly investigated, or you haven't got much background information on what happened. Or it might be allegations of other kinds of misconduct that doesn't amount to a criminal offence, like someone being rude to a customer. But actually quite a lot of relatively low-level misconduct, especially in a taxi licensing context, is a criminal offence. So just be careful about that, but because the distinction is quite important, because if we're dealing with allegations of criminal behaviour, even if they're not formally proven, that's still criminal offence data under Article 10 of the GDPR. Allegations are treated in a similar way, or in the same category as actual formally proven criminal records. Now, that means you need one of those additional conditions. You can't rely on the manifestly made public condition because it's not been proven in the court of law that the license holder's never been convicted of anything. But there are other conditions, and one of them is in paragraph 11 of Schedule 1 to the Data Protection Act, and that requires two things: that the processing is necessary for the exercise of a protective function, and it's also necessary for reasons of substantial public interest. Now, a protective function is defined as several things, and I think that easily encompasses licensing functions, because they include functions that are intended to protect the public against dishonesty, malpractice, or other seriously improper conduct. And for me, that's really what licensing is about, especially taxi licensing, the protection of the traveling public from dishonest or bad actors or people who behave seriously improperly. Okay, so I think you're halfway there already. And then the second question is it necessary for reasons of substantial public interest? Now, I think in serious cases, especially in cases like that Bolton case that was reported by the Manchester Evening News, where the council has decided that the case is so serious that an immediate revocation is required. So it's not appropriate to allow the driver to stay on the road for a minute longer. They've got to be taken off immediately. I think potentially that's the kind of case where it could be publicised, because it is necessary for reasons of substantial public interest. Instinctively, that makes me feel a little bit squeamish, and it probably makes some of you feel a bit squeamish too, but think about it in this way. You might go through this whole process in closed session, and you come to a decision, and the decision is to revoke the license. Now, the taxi driver goes to the magistrate's court and appeals. The appeal takes place in open court. So, I mean, very rarely have I been in an appeal where the press actually attend or even report on the outcome, but they could do. Anyone could. And so you could have taken all of this great care to keep all of this exempt information out of the public domain, but it all gets aired in the appeal. So think about it in that way, that we don't think, well, most of us wouldn't think twice about the open justice principle and all of that information being aired in court. So why is the consideration really any different when it comes to decision making at the local authority stage? So again, just something to mull over there. Where we're dealing with allegations of misconduct that don't constitute criminal offence, criminal allegations or criminal behaviour, the situation is slightly more straightforward, because we don't need to worry about the additional conditions. We're not dealing with special category or criminal offence data. So there are really fewer obstacles to clear before publicising the outcome. It still needs to be lawful and fair. And here's where we come back to my thoughts about reopening the session to make the decision in public, because if a decision has been made in closed session, publicising the decision subsequently would put into the public domain exempt information. It would totally defeat the purpose of going into closed session in the first place. And I think in those circumstances, it would both be unfair and unlawful to publicise information about the driver. Obviously, there is a legal obligation to publicise a summary that withholds exempt information. But if you were to go and name and shame the driver, I think that would be both unfair and unlawful. So if the meeting is reopened so that the decision is made in public, then I think publication of the outcome would be both lawful and fair. So there are a few complexities you might have picked up on in this area, but I hope I've at least given you something to think about, and as I said, discuss with your colleagues in the licensing, legal and comms teams. But if you take nothing else away from this talk, I think my message would be this. As John said, data protection is nothing to be scared about. And I would encourage licensing authorities and licensing teams to be more confident in publicising the work that they and their teams do, not to be daunted by data protection rules. And that's because there can be a powerful public interest in not only allowing greater scrutiny of the work that licensing authorities are doing, but also, as I said at the beginning, scrutiny of the people that we trust to hold licenses in the first place, and holding them to account is what this is about too. So I'll hand over to Ruchi. Thank you very much.
Thanks, Matt. been a really useful overview. And actually, just picking up on what some of the stuff that Matt said, I think this is a question that I get asked a lot as well, particularly around, taxi licensing appeals. But in any event, I think we've spent maybe 25 minutes not joking about COVID. So I think it's imperative we get, talk about COVID again. And I am going to talk today about COVID passports. Now, when we were asked to pick topics for this talk last month, we ended up having to do a fair amount of guesswork about the COVID recovery plan, and in particular, what it might look like for licensed premises. And one of the likely issues that we thought would crop up would be the use of COVID status certifications, also called COVID passports, and not least because the government has been conducting its review into, among other issues, the use of such certification as a mitigation measure. But in light of yesterday's announcement, and at first blush at least, it would appear that we got it somewhat wrong. In his statement, or rather announcement last night, the PM confirmed that moving forward, there would be no legal requirement for the use of COVID status certifications as a condition of entry to any venue or event. That being said, it will remain open for businesses and licensed premises to make use of their own certification process. And one option is that they can use the NHS app, which I will come back to a bit later on. So my initial reaction was one of slight panic, purely because I didn't know what else to talk about for 15, 20 minutes now that the government had just dismissed this whole idea of COVID passports. Luckily for us, however, we didn't get it totally wrong. And when you do go on to inspect the fine print of the policy paper, one can see that the debate is actually far from being closed on this subject. So on the next slide, thanks Matt, I've set out what the sort of the fine print says in the detailed policy paper. And effectively, it says that the government has not in fact ruled out COVID passports. While it considers that it is not currently necessary, it clearly leaves the door wide open to introduce the measure later this year if the country is facing a difficult situation. So as things stand, at least, it seems that COVID passports remain a highly relevant consideration for licensed premises, because for now, at least, it will be for licensed premises to decide if they want to adopt such a requirement for entry, but that in any event, this might in fact become mandatory later in the year if we continue to see either a rise in cases with a knock-on impact on hospitalizations or deaths, or some other change in circumstances or new variant, etc. So before I get into the detail of COVID passports and what licensed premises may want to consider at this stage, it's useful to see how we've ended up in the current situation. Now, as of April this year, and as I'm sure all of you will be aware, the government has been engaging in its so-called events research program. This was a series of trial events aimed at examining the risk of COVID transmissions from attendance at large-scale events, as well as to assess and explore how best to enable people to attend such events safely. Now, these pilot events have been run in phases and across a range of settings, venues, activity types, so that really the idea is that the findings can inform future events of similar settings across multiple sectors. The current and third phase of the research programme includes Wimbledon and Latitude, which is in fact due to take place later this month. So it'd be quite interesting to see how that all pans out. But one aspect of the government's research was around COVID status certification and whether it could be used as a successful mitigation measure in terms of the spread of COVID. So as far as the trial events have been concerned, there was no requirement to show proof of vaccine, but there has been a requirement to provide a basic certification to show that attendees have tested negative for COVID-19 prior to the event. Now, the phase 1 findings of the research programme were in fact published on the 25th of June. And interestingly, going through that report, it just provided no data, no analysis in respect of the use of certification as a mitigation measure. Instead, what it said was that this is all being assessed as part of phase 2 and phase 3. And the report says quite explicitly that phase 3 pilots in particular will provide evidence about using COVID status certification in real world environments and via the use of the NHS app. Given that phase 3 is still very much an ongoing thing, it was therefore a little surprising that the government has now, as of yesterday, also published its findings of its COVID status certification review, and has concluded that COVID passports are just not necessary, at least for now. There seem to be a couple of issues animating this decision. So, well, the starting point, I think, has been, I think the government accepts that there are public health benefits, and there is, clear evidence of that. But what they have identified is, number one, certification is never conclusive proof that an individual is COVID-free. Number two, that when you take all these things into account, ultimately the government considers that there will be a disproportionate impact on those who are not vaccinated, because if you have an entry requirement, then it would require them, it would require non-vaccinated individuals to take repeated tests to be able to attend venues or events or simply social gatherings with their friends. And they felt that would be completely disproportionate at this stage. The third thing is they also looked at the practical burden on businesses, and they felt it imposed a practical burden. I'm not sure that was the evidence of all businesses, but it certainly was, it formed part of the evidence. And some businesses had said that, they felt it would discourage people from attending, again, particularly those who had not been vaccinated and who would have to take repeated tests. And that this was a particular concern for venues that depend on spontaneous trade, which obviously makes sense. Having said all of that, the government report is very explicit that this issue will be kept under review, and that it will be taking into account the findings of its events research program when it's sort of evaluating whether or not to introduce this as a mandatory requirement further down the line. So one assumes that the government will be looking very closely at what comes out of the phase 3 events, as I say, Wimbledon, Latitude, etc. So I think this is very much, we need a space to watch, as opposed to we've certainly not had the final word. Now, obviously the official position is under review, but it is helpful to look at what a COVID certification or a COVID passport would actually look like or entail. And luckily, we already have a template in the form of the NHS COVID Pass. Now, this can be accessed through the NHS app, and it effectively displays one's COVID status. And this app is being used quite widely already for the Jest events and for international travel. So it is a good starting point, and certainly something that businesses have sort of been encouraged to use by the government if they did want to make this a minimum requirement for entry. So your COVID status will depend on 3 things. And again, I assume most people will be familiar with this, but effectively, one, you either have to have sort of be able to prove full vaccination, and that should have been completed 14 days prior to the certification. The second way is by providing evidence of a negative PCR or a lateral flow test, and that has to have been taken within 48 hours of entry to the venue. And then the third and final option is natural immunity, and this is the proof of a positive PCR test, and that it lasts for 180 days from the date of the positive test, but following completion of the self-isolation period. So it's effectively, those are the options. And again, I stress that this is all optional, but there are actually a number of practical reasons why a licensed premise might still choose to run a COVID passport scheme. I think, just thinking through this, it obviously can have a positive impact, particularly if it gives customers the confidence to return to settings that have previously been considered high risk. And, the flip side is that it's also obviously quite valuable if it means that venues can be more confident in operating at full capacity again. So with that in mind, if you are a licensed premises and you are thinking about using COVID passports as a condition of entry, I think there are a few sort of data protection flags that you need to be mindful of. And I think perhaps the first, the first thing I think you need to think about is whether you are even engaging in data processing such that the GDPR applies. Now, unfortunately, this is not entirely straightforward, and there will be some situations in which requiring COVID certification will amount to data processing and some where it won't. So I know John touched upon this in the context of track and trace, and it's important to stress that everything's like very context specific with the GDPR. But on this subject, the ICO has published guidance, and the ICO is the Information Commissioner's Office, and the Information Commissioner's view is that where premises are requiring digital verification of any kind, say through scanning a QR code, even if you don't then keep a record of this digital scanning, this amounts to processing of personal data. On the other hand, the Information Commissioner has said that if you're only using a visual check, so say you at the door, you've asked someone, someone gives you a hard copy document of their sort of vaccination record, or just shows you their phone app, but you don't actually scan anything, and you don't keep a record, then in those circumstances, the ICO thinks that this is not data processing. So there's obviously a distinction being drawn, but I'm still not that confident that it's necessarily a straightforward sort of you just apply what the ICO has said about this, because I do think there could be circumstances where you just have a visual check, but then you are holding some other form of records about that same individual, say through track and trace, you've collected a lot of other data about them. I think that there is a danger that when you combine the fact that they've been let in based on their health status, and the fact that you have all this other information about them, that when you look at it in combination, it might end up being data processing such that the data protection principles apply. Okay, so that's obviously the sort of nuances of the legal framework, but I think in many ways that's irrelevant. And I think practically speaking, and this is sort of going back to what John has already mentioned, in most cases, the GDPR principles are nothing more than sort of fairly common sense, best practice type of principles. And so I think, without worrying too much about, is this caught by the GDPR or not? I think realistically, it just makes more sense for businesses to sort of have regard for the principles in any event, because I do think that they're common sense, they do promote good practice. And in fact, particularly when you think about things like data minimization or, storing for the least amount of time, it actually makes the life of business owners easier in the long run, because it means that you don't end up in a situation where you've collected loads of data and just kind of stored it for 2 years or whatever. Right, so having caveated, the sort of legal framework and the arguments around it, I think in practical terms, the first thing you need to think about are the data protection principles. Now, John has actually covered the basics of this in quite a lot of detail when he was talking about track and trace, and really the same considerations apply. I don't think it's necessary for me to go through all of them again, but I think, do refer back to those slides if you are thinking about COVID passports. And I'll just highlight a couple now. So one is, think very carefully about fairness and, how you operate the scheme. I think fairness is one of those values that really underpins all of data protection. So in this specific context, and again, it sort of links in with what John has said, ensure that whatever system you use, that you always include measures for those people who don't have access to digital solutions, and that whatever you do doesn't lead to any sort of discrimination of minority groups. Say, for example, where, particular groups are sort of more reluctant to take up the vaccine, so the vaccine rate might not be high. And so ensure that the steps that you're actually implementing isn't going to have a knock-on discriminatory impact on certain groups or people. Then think also about, the purpose for which you're using this data. Again, John has mentioned this, and it applies with equal force here. Be very clear why, that you are only using it for a specified purpose. And here, of course, it will be to ensure public health, and that you shouldn't really be using someone's COVID status for any other reason or purpose. And then the third thing I want to highlight is security. So that's the principle of integrity and confidentiality that John mentioned. in the context of COVID passports, I think, just give some thought to how securely you're going to record this data, and also the sort of practical considerations that might apply if, for example, there is an infrastructure failure. So think in advance about how you might tackle that as a business. What would the default position be if for some reason, apps stopped working or someone's phone battery was dead or whatever. Just think quite practically at the outset about how some of these things might play out in real life and moving forward. Right, so the second thing then is data protection impact assessments. Now, there's actually ICO guidance on this, and the Information Commissioner's view is that if you are, as a business, going to use COVID passport as an entry requirement, she considers that this will likely require what's known as a data protection impact assessment. Now, I don't want to get into the sort of legal and technical details of this, but if this is something you are considering and you are struggling with, then it is worth speaking, getting legal advice, and if you have a data protection officer, speaking to your data protection officer. But in effect, I think the reason the Commissioner has taken this view is that that if COVID passports are actually used in sort of everyday situations and restrict people from going into having dinner with their friends or whatever the situation might be, that there is effectively a high risk to the rights and freedoms of the public. And where that is in play, that's one of the that sort of gives rise to the need to do an impact assessment at the outset. The other factor, of course, is that when you're processing this kind of data, it's data about someone's health. And I think, John's already mentioned, and as has Matt, that this is what's known as special category data. And where you have large scale processing of special category data, the GDPR always requires an impact assessment. So again, this is just something I'm flagging, but if this is something that you do need to look into, do speak to someone with the relevant expertise. And then finally, much like the government's own conclusions, my overarching advice to all licensed premises would be is to keep all your processing and your policies and procedures, etc., under constant review. So, at the outset, if you are choosing to have a COVID passport type system, then at the very outset, build in a periodic review or audit so as to assess how the scheme is working, to assess if it's still in keeping with data protection principles, and of course, to make any necessary revisions as and when problems crop up or real life circumstances change. So that brings me to the end of my bit on COVID passports, and I hope that's been helpful. I think we still have 10 minutes or so to answer questions. And just, I can't remember if John said this at the start, but he's had to head off early because he had a court hearing. But Matt and I are around for the next 10 minutes if there are any questions. I'm just going to look at the Q&A. Matt, feel free to jump in if you've already identified questions.
I can see there's Dean has asked a question, not strictly related to what we've been talking about, but I think JT's response is absolutely right. As long as there are no, it's an application for a review. So if the only party taking part in that application is the police, then there's no review for the committee to hear. But if other responsible authorities or other residents have jumped on the review, then as JT says, unless they've agreed that hearing is no longer necessary, it has to go ahead.
Yeah, I would agree with that.
Okay, thanks very much, JT, for that contribution. Looks like we may not have any more. So should we call it there, Ruchi?
Yeah, sounds good to me.
All right, well, thanks very much, everyone, for joining. I can see Sue's come back, so we'll hand over to her.
No, just to say a really big thank you to both of you, and also to John, and I hope everybody's really enjoyed it. No other questions, and thanks very much. Good to see you all.
Thanks.
Take care. I will provide a copy of the recording to everybody who joined the webinar today, and if Matt and Ruchi agree, I can also provide a copy of the handouts that have been used. So
Yeah.
thanks.
All fine.
Excellent. Thanks very much, guys. Take care.